Welcome everyone to History Gone Wilder, part of Half History Will Travel. I am your host, the Wilder Historian, and after the raid on Harpers Ferry, John Brown, wounded, would stand trial for his attack on the federal arsenal for attempting to incite a rebellion. For history-based merchandise, please check out my Teespring store or Etsy shop. You can join the Patreon page to help support the channel and get to vote on upcoming videos and get sneak peeks of previews of videos before they are released. Although John Brown was in custody, the soldiers who captured him had more work to do. The Maryland schoolhouse where a rendezvous was supposed to occur was investigated by a militia company. They found 21 boxes of weapons and supplies, including Sharps rifles, revolvers, pikes, cutlasses, picks, shovels, tents, clothing, stationery, and medical kits. Lieutenant Jeb Stewart led some of the Marines to the Kennedy farm, finding Brown's provisional constitution, letters from Northern supporters, copies of Hugh Forbes' manual, and maps of the southern states. Some of the pikes found at the farm were given away as souvenirs. 5 men were in custody at Harpers Ferry: Brown, Aaron Stevenson with multiple gunshot wounds, Edwin Coppock, John Copeland, and Shields Green. The latter 3 were not wounded. The men were arraigned on 3 charges: treason against the state of Virginia, inciting slaves to rebellion, and murder. Governor Henry Wise wanted Brown to be tried in Virginia to teach the North a lesson. Wise was also vindictive about the raid. It had happened on Virginia soil, and Brown's small party held off nearly 800 militia and other troops before finally being captured. A newspaper reported, when the governor was informed of the mere handful of men who had created all this bobbery, he boiled over. A militia leader would be charged with cowardice by Wise's son in court. Wise, on the evening of Brown's capture, would read some of Brown's papers aloud in Harper's Ferry to illustrate his suspicions that Brown was a representative of the anti-slavery North. In fact, the North turned their back on Brown. Not that the North had been altogether supportive of him in the first place. William Lloyd Garrison's paper denounced the raid on Harper's Ferry, and other anti-slavery Northerners condemned Brown's actions. The lack of support became even more disturbing to the Secret Six, who funded Brown when the letters to Brown from the Secret Six were published in newspapers. They were outed as Brown's backers. Garrett Smith became so disturbed about being associated with Brown that he had a mental breakdown, leading to him being put in the New York State Asylum for the Insane in Utica. He became so consumed with guilt that he contemplated going down to the Charlestown jail and joining Brown. 4 of the Secret Six left the country to avoid possible capture. Frederick Douglass got tipped off that Virginia agents were coming to interrogate him, so he fled to Canada, then England. Other than Smith, the only other backer to stay in the country was Thomas Wentworth Higginson. He was also one of the 2 who stood by John Brown in his actions, calling it the most formidable insurrection that has ever occurred. The other who stood by John Brown but fled the country was Theodore Parker. Parker wrote on his deathbed in Italy that, "Of course I was not astonished to hear that an attempt had been made to free the slaves in a certain part of Virginia, nor should I be astonished if another insurrection or rebellion took place in the state of blank, or third in blank, or fourth in blank. Such things are to be expected, for they do not depend merely on the private will of a man like Captain Brown and his associates, but on the general causes which move all humankind to hate wrong and love right. Such insurrections will continue as long as slavery lasts." When John Brown was asked how he pled to the charges brought against him, Brown rose and stated, "I did not ask for any quarter at the time I was taken. I did not ask to have my life spared. The governor of the state of Virginia tendered me his assurance that I should have a fair trial. If you seek my blood, you can have it at any moment, without this mockery of a trial. I have had no counsel. I have not been able to advise with anyone. If we are forced with a mere form a trial for execution, you might spare yourselves that trouble. I am ready for my fate. I do not ask for a trial. I beg no mockery of a trial, no insult, nothing but that which conscience gives, or cowardice, would drive you to practice. I ask again to be excused from this mockery of a trial. I do not even know what the special design of this examination is. I do not know what is to be the benefit of it to the Commonwealth. I have now little further to ask, other than that I may not be foolishly insulted, only as cowardly barbarians insult those who fall into their power." 2 lawyers were assigned to Brown, and he was asked whether he accepted them. Brown stated, "I wish for counsel if I am to have a trial, but if I am to have nothing but a mockery of a trial, As I've said, I do not care anything about counsel. It is unnecessary to trouble any gentleman with that duty. The trial began on Wednesday, October 26th. All 5 men, Brown, Stevens, Coppock, Copeland, and Green, were escorted by armed guards to the courthouse, where the badly wounded Stevens and Brown would lay on a mattress and a cot in the courtroom. It was decided that Brown would be tried alone, so the rest would be taken back to the jail. Brown pleaded not guilty to the charges against him. Brown would lay on a cot during the trial, but stand when addressing the court. One of Brown's biographers described the atmosphere of the courtroom. From start to close, the courtroom was crowded with 500 to 600 spectators who ceaselessly opened peanuts and chestnuts, throwing the shells onto the courtroom floor. The accumulating shells crunched whenever anyone walked or moved their feet while seated. The spectators puffed cigars and spat tobacco juice on the floor. The air was thick with stale smoke. Periodically, the bailiff shouted that no smoking was permitted, but this resulted in only a momentary cessation, followed by a mass resumption of cigar puffing, interspersed with curses hissed at John Brown. The first prosecutor for the state of Virginia was Charles B. Harding, but he came to court drunk and would also fall asleep during parts of the trial. He would be replaced with Andrew Hunter. Brown's lawyers first attempted to prove that he was insane. This idea came from a group of Ohio abolitionists who sought to soften Brown's sentence. They pointed out that members of Brown's mother's family had been placed in asylums for the insane. Brown admitted that they had, but declared that he was not insane. With insanity off the table, Brown's lawyer attempted to dismiss the trial on jurisdictional grounds. He argued that the charge of treason against the state of Virginia made no sense, because there had been no assault on the state's government and no attempt to establish a rival one. Plus, the crime was committed on federal property. The murder charge would apply here as well. It was done on federal property, not the state's. Andrew Hunter argued that Virginia had long assumed jurisdiction over crimes committed at Harpers Ferry, and this one should be no different. Around midnight on October 27th, a young Boston lawyer named George Henry Hoyt came to join Brown's defense team, but was actually a spy on behalf of a group of Northern abolitionists. He was to act as a conduit for Brown and Northerners, as well as assess possibilities for a rescue attempt. Hoyt was led on to Brown's counsel. However, on October 28th, during the testimony of Henry Hunter, who killed one of Brown's compatriots, William Thompson, and helped fling the body into the river, Brown lost his composure and declared the trial unfair and that his counsel wasn't handling his case appropriately. His 2 lawyers withdrew from the council, leaving Hoyt as Brown's lawyer. Hoyt was just 21 years old, and now he was the lead lawyer in one of the biggest cases in American history. The startled young man didn't stay startled for long. He found that 2 lawyers, Samuel Chilton and Hiram Griswold, were on their way to Charlestown to be the defense counsel for Brown. The next morning the 2 men showed up. They brought in Brown's hostages as witnesses. They testified that Brown treated them with kindness, and that he revealed to them that his raid was one of liberation, not one of murder. When Brown's lawyer asked that Brown be permitted to defend himself against one charge at a time, since it was impossible to deal with treason, murder, and insurrection at once, the judge denied the request. In the closing arguments, Griswold represented the defense, stating that since Brown had no connection with Virginia, then he couldn't be charged with treason to that state. The raid failed, he argued, so how could he have sparked a slave revolt if it hadn't materialized? The final argument was that the battle that ensued couldn't be considered murder. Andrew Hunter in his closing argument stated that treason against one state was treason against all states. Brown had stolen slaves and given them weapons, and if the raid had succeeded, Virginia would have looked a lot like Haiti during its revolution. As far as murder goes, he acquiesced that some of the deaths couldn't be called murder, but many of them were deliberate killings. The jury deliberated for only 45 minutes, and the verdict was guilty on all 3 charges. On Wednesday, November 2nd, John Brown stood before the court to receive his sentencing. Judge Parker asked if Brown wanted to state any reason why he shouldn't be sentenced. Brown fixed his eyes on Parker, leaned forward on his lawyer's table, and said, "I have, may it please the court, a few words to say. In the first place, I deny everything but what I have all along admitted, the design on my part to free slaves. I intended certainly to have made a clean thing of that matter, as I did last winter, when I went into Missouri and took slaves without the snapping of a gun on either side, moved them through the country, and finally left them in Canada. I designed to do the same thing again, on a larger scale. That was all I intended. I never did intend murder or treason or the destruction of property, or to excite or incite slaves to rebellion, or to make insurrection. I have another objection, and that is, it is unjust that I should suffer such a penalty. Had I interfered in the manner in which I admit, has been fairly proved, for I admire the truthfulness and candor of the great portion of the witnesses who have testified in this case. Had I so interfered in behalf of the rich, the powerful, the intelligent, the so-called great, or in behalf of any of their friends, either father, mother, sister, wife, or children, or any of that class, and suffered and sacrificed what I have in this interference, it would have been all right, and every man in this court would have deemed it an act worthy of reward rather than punishment. The court acknowledges, as I suppose, the validity of the law of God. I see a book kissed here which I suppose to be the Bible, or at least the New Testament. That teaches me that all things whatsoever I would that man should do to me, I should do even so to them. It teaches me further to remember them that are in bonds as bound with them. I endeavored to act up to that instruction. I say I am too young to understand that God is any respecter of persons. I believe that to have interfered as I have done, as I have always freely admitted I have done, in behalf of his despised poor, was not wrong but right. Now if it is deemed necessary that I should forfeit my life for the furtherance of the ends of justice, and mingle my blood further with the blood of my children, and with the blood of millions in this slave country, whose rights are disregarded by wicked, cruel, and unjust enactments, I submit, so let it be done. Let me say one word further. I feel entirely satisfied with the treatment I have received on my trial. Considering all the circumstances, it has been more generous than I expected. I feel no consciousness of my guilt. I have stated that from the first what was my intention and what was not. I never had any design against the life of any person, nor any disposition to commit treason, or excite slaves to rebel, or make any general insurrection. I never encouraged any man to do so, but always discouraged any idea of any kind. Let me say also a word in regard to the statements made by some to those connected with me. I hear it has been said by some of them that I have induced them to join me, but the contrary is true. I do not say this to injure them, but as regretting their weakness. There is not one of them but joined me of his own accord, and the greater part of them at their own expense. A number of them I never saw and never had a word of conversation with till the day they came to me, and that was for the purpose I have stated. Within Brown's speech he had lied. A gun had indeed been fired and a man killed in the Missouri slave liberation. Also, Brown fully intended to launch a slave insurrection. As he said on many occasions, he wouldn't strike out with the purpose of killing, but if someone tried to stop the slaves from joining him in the mountains, then he would have no choice. Still, the speech had a great impact. It was published far and wide, gaining great attention throughout the North. After Brown spoke, Judge Parker passed sentence. John Brown was sentenced to death by hanging on December 2nd.